Good morning, ladies and gentlemen. I was asked to talk about the ethics of assisted dying, and then particularly in the South African context. I'm mindful of the time. I see 60 minutes were allotted to me. I'll keep it much shorter than that so that we can have a question and answer session, as the chairman has said, at the end of the session. I'm also mindful of the fact that it's 15 minutes past 9. I only have 9 slides, luckily. And I know that if one talks to the slides and gives some background and flesh them out, a few minutes can double up very quickly. So I will try and keep to the slides. They're fairly populated. They're fairly evident, self-evident. I want to suggest to you that talking about the ethics of assisted dying is, although a very interesting exercise, looking at arguments for and against, I'll look at some of them very briefly. I think the real debate is about the ethics of legalizing or decriminalizing assisted dying. That's where the ethical debate should be. In other words, the ethics of public policy. And in the South African context, it is interesting that the ethics of public policy cannot avoid the Constitution of South Africa, the 1996 Constitution, which has a Bill of Rights, which I consider to be an ethical document. So it's actually very convenient to have that document as the guideline for developing our public policy. So the ethics of assisted dying in the South African context, in the context of public policy, is one of the ethics of the Constitution. I want to start, there are the 9 slides. You'll see I'll talk about general background topics before I get to specifically arguments for and against the ethics of assisted dying, and then the Constitution. Let me start with a philosophical introduction that may seem pretty obvious. The points I want to make are pretty obvious. But in debate, we find that these obvious points get obscured by people, for example, who oppose assisted dying. I want to make the general point that, normally speaking, life is good. We value life. We value life, and I mean physical life, our bodily life, because it makes possible all those goods that we value in themselves. Fulfilling personal relationships, friendships, family, good books, good music, a fulfilling job, nature. All of those things that we enjoy, that make life worthwhile, are premised on a physical body. So there's a conceptual and, I would say, factual connection between life and good. The opposite is true, that death and dying are bad, precisely because they destroy. And I make a distinction between the process of dying and the ultimate result, death. They destroy the necessary condition for a worthwhile life. They destroy the necessary condition for what we value in itself. But dying is an inherent part of life, and our lives are thus inevitable for all of us. Dying is inevitable. Now, that may seem very obvious, but if in the medical profession there's an insistence on saving lives come what may, this truth is forgotten. That if we talk about life, death is part of it, and we will all die. It's obvious. But that impacts on the choices we make in the end, and it impacts on the duties we assign to medical professions. professionals. How do we die? I think if the two of those three ways of dying that I've sort of that I set out there, if they were the only ways in which we die, then we would not have had a problem discussing assisted dying. Yes, of course, there are, I need to qualify that. There's a notion of a completed life, which also came up yesterday. But if we die suddenly through trauma, an accident, without suffering, there's no problem. If the process is a gentle one and peaceful, one of peaceful decline, gentle decline, adequately controlling suffering, barring issues like a completed life, there's no problem in respect of assisted dying. But if the process of decline is consumed by unbearable and intractable suffering, I know some call it irreversible suffering, then assisted dying becomes an issue. And unfortunately, that is the reality for some people. We do not know how we will die, but that is the reality for some people. Then seeking assistance with dying becomes an option, provided it is voluntary, a voluntary request by a competent person. So we sit here with a nexus of competence, voluntary request, free request, not made under duress, and suffering. That is why we deal with the issue of assisted dying. That's why it's ought to be on the social agenda and the legal agenda of a country, and particularly in South Africa. Talking about suffering, the way I look at it, suffering is induced by either pain, physical, in other words, physical suffering, or by distress, psychological or mental suffering, or it can be both. Now, how should we approach physical and mental suffering that is unbearable and intractable in the dying process? Modern medicine, on the whole, seeks to control suffering and extend life. But the fact is that it has limits because of the inevitability of death. To simply say that these duties of modern medicine, to lengthen life, to preserve life, to stop suffering or diminish suffering, that those are the duties of modern medicine, come what may, is simply unacceptable. Modern medicine has to come to terms with the fact that life is finite and that the duties of professionals take on a specific shape at the end of life. Now, even the South African Supreme Court, SCA stands for the Supreme Court of Appeal, in the Strantham-Ford appeal, 6th of December 2016, said modern medicine can lead to the process of dying being protracted, painful, and burdensome, with a low quality of life and loss of dignity, suggesting that we need to look at medical treatment in a different way at the end of life if intractable and unbearable suffering is the case. If we look at choices in our healthcare and medical treatment, from a point of view of ethics, but also, luckily, from the point of view of legislation, the National Health Act, and the Supreme Court of Appeal, it is a fact that in South African society, if we are competent, we have a moral and legal right to make choices in respect of all our healthcare and healthcare decisions and medical treatment, even if a refusal shortens life. So we can make that choice because informed consent is recognized, provided we are competent and have a free and make the choice freely and not under duress. Now, this also may sound very obvious, nothing revolutionary, but it is not accepted by our Minister of Health. At least what is in writing in a response to Deirdre Carter's question to him in Parliament. He says that decisions are only made by medical professionals. In other words, he denies what is in the legislation and has been confirmed by the Supreme Court of Appeal. In fact, our legal position is that, and that was confirmed again by the Supreme Court of Appeal, that treatment without our consent, barring exceptions like an emergency, constitutes assault. So those are the decisions, the foundation for making decisions throughout our lives and at the end of life. I hope in the discussions later today and perhaps during the Q&A, we will talk about palliative care. Because I think that one of the issues that needs to be resolved in South Africa is whether palliative care excludes the need for assisted dying. There's a belief that that is the case. I do not agree with it, for the reason of autonomy. I think human beings are characterized by the fact that they can make decisions for themselves, that they can take responsibility for their decisions. Now, it may be different in the jurisdictions or the countries you come from, but certainly the debate in South Africa, whether underlying or explicit, is about this notion of autonomy being a selfish one. That I just think about myself, that there's a kind of arrogance and hubris attached to autonomy. How can I, in the end, at the end of my life, despite whatever suffering there is, think that I can take the decision? Surely the community should have a say in it. So what we have, in a philosophical sense, we have here is a standoff between what is called individualism and communitarianism. There's a belief that my decisions should be made in conjunction with members of my family, with the community, larger community. If somebody chooses to do that, that is fine. But our Constitution allows us to make decisions for ourselves. I think the confusion often is one of between how we are shaped and constituted as human beings. We become human beings in community with others. I would not have been a person. I would have not have had a language. I would not have been myself in any significant sense of the word if it had not been for other people. There but for the grace of others go I. I'm not an island. So we recognize that. But when it comes to individual decisions that touch us in the most fundamental way, to deny us that choice that makes sense for us in our particular circumstances is a confusion of two things. In other words, how are we shaped as people, and how do we make ultimate decisions for ourselves for which we take responsibility? Particularly if we consider that throughout our lives, we don't bother much with one another. I make my decisions throughout my life about my career, about friendships, about all kinds of things that I do. But lo and behold, if I'm in that bed and I have 3 weeks to live and I'm going through intractable and unbearable suffering, then people have a concern with me. I'm pretty cynical about that. So I believe that whatever we believe about communitarianism and the value of community and of relationships with family and friends, we may reach a point, some of us who don't die in a certain way, where our choice and our interests trump those of all others and all other considerations. What then about palliative care? I do believe that it is non-negotiable. It's an enormously important part in discussing decisions at the end of the life. Of course, in reality, in South Africa particularly, it is hugely variable. There are very few institutions with adequate palliative care, which also impacts, obviously, on the way in which decisions are taken at the end of life. But even if palliative care is optimal, is the best one could conceive, it has limitations, because not all suffering can be adequately palliated. We need to respect the autonomous choice of competent persons to forfeit palliative care and end suffering by choosing death in appropriate circumstances. And as I said earlier, we need to discuss, in the South African context at least, whether terminal sedation, palliative sedation, is adequate to such an extent that it excludes the necessity for assisted dying. I don't believe that terminal or palliative sedation is the answer. I do not wish it for myself, and I respect others who do not wish it for themselves. I think it's an assault on my autonomy, on my dignity. But I am sure we will, in the debate this afternoon, a palliative care specialist will be present, and I think we ought to pay due respect to that point of view, and there really is a point to debate. In South Africa, precisely 20 years ago, a report was issued by what is called the South African Law Commission. It's now called the South African Law Reform Commission. It was appointed in the mid-90s by President Mandela as state president. The commission is chaired by the Chief Justice. At the time it was Justice Ismail Mohammed. It was a response to a request from a Living Will Society, called SAVES at the time, to have living wills, or more generally advanced directives, legalized. There was an intensive process of studying the situation worldwide, soliciting opinions from South Africans. So there was a first report, and then that was published, soliciting opinions from the public. And a second report was published in 1998, the final report. It had a bill about end-of-life decisions appended to it, a draft bill. It divided end-of-life decisions into these 4 components. I'll run through them quickly, but the point is that that report was duly handed to the Minister of Justice because it involved law reform, and to the Minister of Health. That report has been gathering dust ever since. Pain management is an issue because we have proof, we have evidence that pain is not, especially at the end of life, not properly addressed. There's also the fear of medical professionals that if they address pain adequately, they'll shorten life and they expose themselves to medical risk. Still, it has not been addressed. Withholding and withdrawal of life-sustaining treatments was the second area, called passive euthanasia, I think inappropriately. It is a practice, it's standard of care in South Africa. But there are borderline cases where doctors, again, fear criminal or civil liability, particularly where family members do not agree. So there's an area which needs to be clarified. It has not been done. A third area I'm much more optimistic about with Deirdre Carter's initiative. You may know that there's a draft bill was published in the Government Gazette just a few weeks ago on advanced directives, those 2 forms of advanced directives. But even so, there are people who are, I don't want to use violently, but strongly opposed to living wills, who believe, living wills and durable powers of attorney for healthcare, who believe that the decision is for experts, palliative care experts, for example. I believe, Deirdre, you will talk about it, but with many submissions made. The process, Deirdre will discuss with you. So there's some hope in terms of number 3. Now we get to number 4, assisted dying. What the Commission did was to leave open 3 possibilities. It did not want to take a position. One was simply to leave the status quo as it is. The other one was it's simply a decision, assisted dying, in both its forms. Importantly, the Commission said there's no real difference between the two. There's no significant difference between assisted suicide and voluntary euthanasia. The second option was that it's simply a decision between the attending physician and the patient, with obviously all the safeguards, hopefully not 68 like in Victoria. But the third option was that a committee should somehow be involved. Now, turning to assisted dying, this is what I would say some of the most important arguments on both sides. And I'll run through them very quickly. I've talked about autonomy. Why do we insist on the right to assisted dying? Because we are human beings, and human beings are autonomous beings, and it's an exercise of autonomy that we make decisions for ourselves, that we're not controlled by others, not ruled by others. Particularly the argument will be the strongest right at the end when we are consumed by suffering. Overlapping with the second argument, suffering, which is intractable and unbearable, is a reason for assisted dying. It is a reason why we would want, even in our Constitution, we have a right to life, why we would want to say, I forfeit that right. It's more important to get rid of suffering and to end my life than to claim a right to life, which at that point has no meaning. The third argument is one that I think is particularly strong, but it's very seldom used. And that is what I call the moral equivalence between, call it for short, passive euthanasia with withholding withdrawal of treatment and active euthanasia. Why is that? From an ethical point of view, from a moral point of view, from a philosophical point of view, all the variables are relevant to both of these practices. And we cannot say in principle that all actions that fall under passive euthanasia have such features, and those falling under active euthanasia are different. You cannot say that in general. One has to look at it on a case-by-case basis. It may be, and that's the only point that counts, that in terms of the deliberation we have, the intention, the motive, the decision, responsibility, the actual action, and the consequences of that action, the two may be exactly the same. There's no way we can say all actions falling in one class are acceptable and those in another class, talking about active-passive, are unacceptable. And the fact is that passive euthanasia, withholding and withdrawal of treatment, is standard of care and is subject to the same risks as active euthanasia. And we have statistics showing that Groote Hospital, where the first heart transplant took place, and British hospitals are exactly on a par. Certain identified British hospitals are exactly on a par in terms of withholding and withdrawal of treatment. There is no abuse. I always find it strange to think that when it comes to the end of life, where compassion should rule, that you would find people who want to end life, who actually have evil motives. It's not the case with withholding and withdrawal of treatment because the variables are all the same and could be constant. It would be no different with active euthanasia, which is contemplated in a situation of compassion, terminal suffering, or simply unbearable suffering, in a professional situation where family and concerned people are together. Why we would want to bring in motives that are out there in society, and heaven knows what happens in South African society. Why we want to bring all those societal factors to bear upon this situation in a professional, compassionate situation, why we want to bring those arguments to bear on that situation leaves me baffled. I have about 5 minutes. Fantastic. The arguments against, and I think this will come up this afternoon. One of the strongest is that it will lead to abuse, bad consequences. First of all, the body of evidence for abuse has to be looked at. For example, we would argue that if we follow the Oregon route, we look at annual reports of 25 years and ask, where are those? Where's the evidence of abuse? The opposite of that would be to ask, what is the effectiveness of safeguards in other jurisdictions? The fact is that this is not a principled argument. This is only an argument that kicks in when you say, well, let's assume that we accept that assisted dying is morally acceptable, ethically acceptable. How does it work? It's an argument about evidence. And if the evidence is not there, then the argument should be abandoned. The second one is the integrity of the medical profession. That is that the doctor's duties are to save lives and to palliate suffering. I've mentioned that these duties have to be interrogated in the context of an inevitable death and suffering that's unbearable and intractable. It cannot be contextualized in a situation where we say, we will live forever. But it's as if so many in the medical profession think that way. And others. Playing God, obviously the arguments there, how do we know God's will? Which religion? And if you take a particular religion, which version of that religion? And when I say, if we take Christianity, for example, Archbishop Tutu, the Archbishop of Canterbury, are for assisted dying. People remain silent. They persist with this argument that we are playing God. But I think the knockdown argument here is that if this is playing God, then our whole life is playing God. Then every decision we take is playing God. Then medical decisions, antibiotics, surgery, they're all playing God. Because at issue here is the time and the manner of death. And if we control that, if we have a say in that, it means we're playing God, and then you can't isolate only assisted dying. I just want to come back to autonomy. In the South African context, I find that in debates with Doctors for Life, it's often said that arguing for assisted dying, trying to legalize this practice, to decriminalize it, will lead us to Nazi Germany and the Hitler's euthanasia program. It's not just here, you know, in America, when I taught at the University of North Carolina for quite a while, there were ethicists who, you know, in the United States who argued the same. Art Kaplan, for example. Research was done when they were still alive amongst survivors of Auschwitz. And by a majority of something like 97%, they could see no likeness between medical euthanasia and Hitler's programs. I've reached a stage, and I don't want to be controversial, but these are the issues that come up in South Africa, where I refuse to debate, and I think that's, in a sense, it goes against my grain, but I refuse to debate with Doctors for Life about if this argument comes up and one does not, and it comes up in public debate on radio or television, and I'm not given the time to rebut that. I think it's disingenuous to bring that point in. 1 minute. The ethical debate, and I've listed 3 arguments on each side, I believe is interminable because of personal, religious, and cultural convictions. In South Africa, we have legal practices that the majority do not support in terms of the evidence that we have. Termination of pregnancy, called abortion elsewhere. Polygamy, think of our previous president. I believe he's going to take a 5th wife. Same-sex unions or civil unions are all legal or constitutional in South Africa. Capital punishment is not. With all of these practices, I dare say the majority of the population do not agree. But the Constitution says you have a right to participate in those practices. And of course, they don't harm anybody. Those are your choices. The same should apply to assisted dying. We have a constitution which I consider to be an agreement that we reached. We didn't literally sign a contract, but in virtue of being a South African citizen, you subject yourself to a constitution which is an agreement that we would build the good society, and heaven knows we fail in many respects. We are successful in other respects, but we would build it on the values of the Constitution as expressed in the rights of the Constitution of the Bill of Rights. What has happened is that there's a conflict, a tension between our common law, which is assisted dying as murder or some like crime, and the Constitution which supersedes the common law. And the common law needs to be developed. Let me just end off by saying this is what in the Strantham Ford case, a full bench of 5 appeal court judges said, the common law will no doubt evolve if a new case comes up. We will hear about that this afternoon. There's one pending. With the declaration of incompatibility, in other words, of our common law and our constitutionally protected rights, joined with the suspension of the order to enable Parliament to remedy the deficiency. Now you will see that is what has happened in Canada. In other words, we foresee and we sincerely hope that we're going to walk that path. We foresee that we might walk that path, where the court simply says Parliament has to address this. Now, given what I've said earlier, Parliament has sat on draft legislation for 20 years. It actually needs the court to force its hand. I will not say anything about tough questions that we can have the laundry list of Victoria, 68 conditions if we get to the point where we have to implement assisted dying and right safeguards. The issues that come up in South Africa most of the time are issues of depression, and should suffering be terminal, in a terminal context or not. I think I should end there, but it's sort of 2 minutes over time. Thank you.